If you and your spouse signed a premarital agreement before you got married, and your premarital agreement states that you will each keep your assets separate and they will remain your separate property, even the earnings you accumulate during your marriage, then yes, when you get divorced, your assets will remain separate. Most people don't have a prenup. Most people, even if they don't have a prenup, believe that if they keep their assets separate during their marriage, that they won't need to worry about it. They're wrong. You need to go to a family law attorney's office, and that family law attorney can advise you as to what interest your spouse has accrued in your marital assets and what interest you may have accrued in his or hers. Now, just because you've accumulated a community interest, or your spouse has, in your assets, that doesn't mean that they have to be divided that way. See, here's the thing. If you and your spouse are able to reach agreements to something different, that's great. You can sign off on that and have it filed with the court. But if you and your spouse are unable to reach agreements, then I'm sorry, your assets will need to be divided based on California law, which likely means that savings account that you thought was going to be yours and yours alone no matter what, you're going to have to equally divide.